Hello, my name is Thomas Gage. In this case, I'm a plaintiff who is exercising in pro per his right granted under the First Amendment to the United States Constitution, which intended to protect and preserve the right of we the people to criticize our government and to seek redress of grievances for the abuse of power against the individual rights of the only sovereign in this nation. This motion, filing under Rule 201, Judicial Notice, Adjudicative Facts. This is on appeal from docket number Morristown L-1042-13. The case comes from State Judge Rosemary Ramsey. This is Thomas Gage, plaintiff appellant versus Sleep Hollow Warren LLC, State Judge Fred Cuff, Attorney Joseph E. Murray, Attorney Alan A. Siegel, Marian Camerata and Brock Camerata. Defendant respondents. Okay, and the Jersey Rule Evidence 201. I hope this motion goes before a judge that has at least a human heart and cares about the integrity of the courts. Here says, may take judicial notice on its own. Must take judicial notice if the party requested and the court is supplied with the necessary information. So based on the rules 201, judicial notice of adjudicative effect, the court must, in this case, take judicial notice because I'm requesting and I'm gonna supply them with the necessary information, with the exhibit of which you're about to see now here. The exhibit in this case are A, B, C, D, E, F, G, H, I, and I'm gonna send 3 CDs with this. So this is basically I'm supplying the court with the necessary information, which are exhibit that proves felonies. Exhibit A here. This exhibit A has to do with the Colley and Sordillo conflict of interest. It's issue here. Okay, exhibit 2 pages. I'm gonna show exhibit B. Okay, the case information of this is the one of the case I filed in Somerset County. It was assigned to Judge Fred Kaufman, and this one here I demand jury by trial by jury here. Okay, and you see here I have a check and jury demanded. So but I never got it. They denied me my constitutional right. Let's see, jury demanded, sign it. See, this is the verb. Okay, then I got the exhibit C, 4 pages. That's to do with the transcript. When I find out on the trial day that I was prepared to present my case to before a jury, a peer of 12 or 6, but I went there and then I said to the judge, there was more here. Right here I can say, I mean, there is a lot more than this. Your Honor, I thought that today my trial stated with the jury here, and I don't see it. So I don't know why I didn't have a jury. And exhibit D has to do with the case management conference, okay, which they were aware about my demand trial by jury, and I was also I was deposed to about the allegation that I was talking to, and so everything was set for a jury trial, but I never got it, obviously because the criminal evidence that I would have before a jury were incarcerated officers, and then that's the reason why it didn't happen. Anyway, exhibit E here, this shows the Mr. Colley is members of the law firm Di Francesco, Batman, Colley, Epstein. This document shows you the conflict of interest, the conflict the Colley had in the Sleepy Hollow development in regard to the property's land. Okay, 2 pages of this. Okay, save it. And here we have Warren Township Planning Board meeting minutes. Okay, this minutes shows who voted on that day, and this shows the fact that the Sleepy Hollow had 2 part of hearings, and this first part is completely missing on a transcript provided me by Marine Camarata. The part that's missing was relevant to my case, and you're gonna see it. I do have a video on YouTube. You can go and look at it, and I explain to you what it is about. So basically here you can see the minutes shows you who was in favor that day. In favor, Mayor Sordillo, Mr. DiNardo, Mr. Kaufman, Mr. Poloting, Ms. Smith, Mr. Villani, Mr. Linder, and Mr. Garlic. Now, in this one here, it's obvious that Sleepy Hollow approval was unlawful because lack of quorum, due process of law. A quorum on the planning board must be 5 members, eligible 5 members to hear a case. In this case, Mr. Sordillo had a conflict of interest in the land. He excused himself, and now he's voting on it. Mr. DiNardo excused himself, and now he's voting on it. Kaufman was the only, here he was eligible to be. Mr. Plochting, she never heard a case. She was absent to the previous cases meeting here, so she was not allowed to be there. Mrs. Smith, she was allowed, and Mr. Villani was allowed. Linder had a conflict of interest with the attorney representing Sleepy Hollow, so Mr. Sordillo, DiNardo, and Linder and Garlic, they were supposed to be excuse himself from this case. So would have been only 3 members here. 3 members does not make a quorum to be legally allowed approval for Sleepy Hollow. So the Sleepy Hollow approval has been a fraud, and it is a fraud, and then so therefore it's avoided by law. Okay, it's avoided. Now, the original transcript of Monday, March 7, 2005, the exhibit G has to do with the conflict of interest with the traffic engineer, Mr. Dean, is missing on this transcript. It's found on the audio and the CD, which I'm gonna submit to the court. And transcript of October 22nd, 2007. Here, this is the relevant part that's missing, which you saw in the minutes I showed before, the planning board minutes. So this only, shows the second part. Let's report on this, and then therefore it's corrupt. All right, obstruction of justice, and this one here, and I got exhibit I. Okay, transcript of proceeding of February 25th. Here I'm gonna say DAC number here and team 3 like this. Then I'm gonna put CD in it. 3 CD in there. I'm gonna close this package here. Okay, and I'm gonna put it right in this one here, right there, and we're gonna seal it. This goes to like that. Alright, and this is goes to the post office, and then I'm gonna send the copies. Alright, copies to Attorney General office in Jersey, and to Sheila and Francesco and Robin. I do this tonight. I'm going to the post office right now, and I'll be back. I'm gonna come back with the receipt. Alright, and then I will keep you posted on this. If the judge is gonna dismiss my case and you're in this evidence, you will know. I will put in a video so you can you can see what's going on with the judiciary system in New Jersey. Okay, I just came back from the post office. Today it's August the 22nd, 2013. I mailed a package of the motion that I filed under Rule 201, judiciary notice of adjudicative facts. This is the notice here, so that's what I did. And then this is the law, the rule that says the court must take judicially notice if a party requested it and the court is supplied with the necessary information. As you saw it, I supplied all the information that I needed, the exhibits and CDs, and says here timing is the court may take judiciary notice at any stage of the proceedings. So I'm complying with the rules. Okay, it was adjusted that says the rule requires. Now this is in regard to an appeal in regard the case that was dismissed in my case that was dismissed in Morristown courthouse. This is the order. This is the order that denied me then on this day of 24th day of May 2013, order as follows. Plaintiff motion seeking judicially notice and evidentiary hearings is denied. So this was before the trial court, and the judge assigned to this case was Rosemary Ramsey. She did violate the rule of a judiciary notice, and that's why now I'm filing the same motion of adjudicative facts in appellate court now. Okay, based on the same evidence that were submitted in the trial court. Okay, so you can see here my rejection of this order. I said this is a violation of due process, a violation of a statutory procedure. Is a fact, because says here the law clearly says that must take judiciary notice if a party requested. I did request it in the trial court, and then this was denied to me, as you see here. Okay, it was denied, but and then I rejected and I sent it back. Okay, so this is all the names of the defendant include this packet here, right? And the state judge Rosemary Ramsey, she had this evidence that I just sent to the appellate court before her. In that case, she concealed the fact that there are criminal evidence, okay, misconduct, forgery, perjury, all that, like I said before. Appellant the review of judicial notice decision. In reviewing a trial court decision, taking or refusing to take judicial notice, like in this case, the trial court now refused to take judicial notice on my case. Appellate court have used an abuse of discretion standard rather than more than a deferential, clearly erroneous standard used to review finding of fact based on the admissible evidence. In this case, the court is free itself to take a judicial notice of fact. The trial court refused, in this case, to note or to take note of certain facts which you just saw. Okay. Now, I'm gonna leave it like this now, and then I will see what happened with this submission of the motion. If the case will be dismissed, I will let you know. Okay. Also, further, I'm gonna talk about the dismissal of my case. The judge acted without jurisdiction. In opposition of my motion on the Rule 201 for judicial notice, I received this opposition by J.B. Bone, the attorney who represents Sleepy Hollow LLC, Dory Dungeon, and Joseph A. Murray, in reference of my case. As you saw before, the motion that I supplied to the court with the exhibits, which are criminal evidence, are evidence of felonies. And this is the position here, which says, in opposition to appellant the motion for judicial notice, in support to cross motion. Now he's filing a cross motion for partial summary disposition, dismissed pursuant to Rule 2.5-2, and direction to appellant to comply with rules. It's funny because here we have an attorney that is filing a motion in regard about the rules. What is that I don't understand is why I should comply with any rules, since they have been breaking all the rules. Most important, they have been breaking my constitutional rights, violated them. Now, you're talking about rules. I am a pro se plaintiff. I'm a beneficiary of the Bill of Rights. I'm the one contracted the court in my behalf as a beneficiary of the Bill of Rights, which the court has a fiduciary duty with me to make sure that my constitutional right has not been violated. So I contracted the court and filed a motion with this exhibit which I prove the violation are felonies. And so what rules then I comply with? It's not my fault. The State Attorney General refused to do his job, refused to take over this case, which is a criminal case. I have no fault here. I am only acting on self-defense due to the violation of my constitutional rights, and therefore I filed this appeal. He's talking about rules because he belongs to Association of Bar, Lawyer Association of Bars, and he has the rules. He has the rules in regard to his code of judicial conduct. For example, I'm gonna give you an example. Mr. Bond and other lawyers involved in this one. The state RPC 8.2 judicial and legal officials says A lawyer shall not make a statement that the lawyer knows to be false, or and B says a lawyer who has been confirmed for judicial office shall comply with the applicable provision of the Code of Judicial Conduct. So you do have rules here, okay? So tell me about the rules. I would like to know why you have been ignoring the criminal evidence which I submitted now. It's obvious they are criminal, such as the manipulation, the transcript provided by Pratt Camerata and Maria Camerata during legal proceedings, and their violation committed under Perjury General 18 U.S.C. 1621, and false statement under 18 U.S.C. 1001, and the New Jersey 16-7, false swearing and making proof of publication, perjury under 2C 5-2, conspiracy. How can Maria Camerata be allowed to get away with her crimes? The false swearing in making proof of publication, perjury. Okay, now this is section 1(6)(4). This is deemed guilty of perjury. Now, how about that? Did you comply with the Code of Judicial Conduct? So how can you dare ask the court to dismiss my case because I did comply with the rules, as by refer to no lawyer per se litigant is not to be held to the same standard as the practical lawyers. That's obvious because we didn't go to school to practice all this regulation. But we are here as a per se to protect our rights, which are being violated, and this is shown by my evidence that exactly what happened. Now, you are not the only one here objecting my motion, but also we have the DiFrancesco Batman Colipstein law firm. In this case, the lawyers who are here representing attorney defendant Alan Siegel, the Warren Township Planning Board. In this case is Michael V. Cresitello. Well, he also, agree with J.B. Bond to have the court dismiss my case. Obviously, after all the evidence submitted before the judge, which I believe is hardly cannot do that, because the judge will be also in violation of his ethic code, right? Because provide criminals, I will say, like evidence of felonies. So the judge has the duty to report them and cannot dismiss a case when the plaintiff is a victim. Okay? The law says an officer of the court, which you are, of the state, with an obligation to the court and to the public no less significant than his obligation to his clients. Thus, an attorney occupies a dual position which imposes dual obligations. His duty is to the courts and to the public, not to the clients. And whatever the duty is to the clients, conflict with those they own as an officer of the court and the administration of the justice, the former must held to the letter. So, Mr. J. Bond and Mr. Mike Crisitello. Have you been ignoring the criminal evidence such as the manipulated transcript provided by Pro Camarata and Maria Camarata during legal proceedings? Their violation committed under perjury generally and false statement and false swearing and in making proof of publication, perjury under 2C5-2, conspiracy, false swearing in making proof of publication, as that is the manipulated transcript. But whatever, with this judicial notice, the court has now knowledge of the overwhelming exhibit materials that have been submitted before by me, the appellant. Okay, and now have become fraud records in this court of appeal. If you further have a proposition on my motion, so you should also contact the State Attorney General, which here stated, here you can see the State of New Jersey Attorney General state in this mission statement that the Attorney General as head of the department served as the state and chief law enforcement officer and legal advisor, and is responsible for the management and administration of the department. The Attorney General oversees the criminal justice system. The department also protects consumers against fraud. So you can, if you don't like if you have anything against my motion and you're talking about rules, tell the State Attorney General to comply with these rules. Okay, so everybody comply with the rules. That would be fair, isn't it? My fellow Americans, since that I filed appeal, I didn't receive yet any kind of scheduling, so I did contact the clerk office asking for that. I did send an email on 9/3, 2013. I did receive a reply on September 9th, 2013 from Mike. It says that the office had prepared a scheduling order, which I still not received it yet, but I hope by Monday I will. Today is the September the 15th, so I'm looking forward to scheduling, and then I will keep you updated on this case. I want to show you as the progress goes with this court, how they're going to handle this case.